Hello, good morning, everyone. Welcome to the ALSA Indonesia Legal Training and Workshop that we will discuss about legal English 101 in this lovely morning. So, my name is Agaton Henrianto. I am an assistant lecturer in the Department of Administrative Law, Universitas Gajah Mada. Today, we're gonna have the first discussion of the whole ALSA Indonesia Legal Training and Workshop, which we will focusing and discussing about the legal English 101, especially in the alternative dispute resolution. Today, together with us, we have Dr. Harold Sipol. And Dr. Harold Sipol is an international dispute resolution practitioner with more than 12 years experience. Currently, he is the academic director of the Bali International Arbitration and Mediation Center. Good morning, Mr. Harold Sipol.
Selamat siang.
Selamat siang. Terima kasih sudah bergabung.
Terima kasih kembali. Thank you very much for the kind introduction and generally for the invitation. And good morning or selamat siang to everyone who's joining on YouTube. It's my great pleasure to be here today and to do this workshop. Now, let me share my screen and let's get into medias res right away. So today we speak about the use of English in ADR.
I'm sorry, Mr. Harold, before we start,
yes.
Probably I just should remind the participants today that after this session, after you present the materials, we will have a Q&A session, right? So all participants are welcome to raise any questions regarding the use of English in ADR to Mr. Harold, and we are open the questions that you can type your questions in the comment box in the YouTube live, and the committee will send your questions to us to be answered by Mr. Harold. All right, so I guess without further ado, Mr. Harold, the floor is yours.
Okay, thank you. Sorry for skipping the formalities. And maybe on that note, if you are a student and your English is not so good and you're sort of worried, since the questions are sent to the committee, feel free to type them in Bahasa Indonesia, and I'm sure they can be translated for me because my Bahasa, as you heard, is unfortunately not very good. I was saying that we speak about the use of English in ADR, which is alternative dispute resolution. I'll get to that in a minute. And as a preliminary remark, what's very important for you out there to know is that I am not a native speaker. And I submit today that's sort of my main argument, that irrespective of who you are, irrespective of what you do, as long as you do it the right way and put in a sufficient amount of effort, you can acquire a certain level of English, which is not just any level of English, but a level of English which is definitely good enough to act in alternative dispute resolution. And when I say act, I mean to actually earn your money doing that and not look like a fool. So what are we going to cover today? Let me briefly go through this. I'll first give you an overview of the types of dispute resolution or alternative dispute resolution. I want to make sure that we're all on the same page here and that you don't have a misunderstanding. I will then speak about how English is used in dispute resolution internationally, again with the focus on alternative dispute resolution. I will tell you what types of skills in English you need in order to succeed. And I'll run through a few ideas, very simple stuff on how you can improve your English. If we have time, I'll try to be fast. I'll highlight to you some common mistakes which I see in international dispute resolution. And again, keep in mind, this comes from a non-native speaker. So it's definitely something which shows when people don't do it the right way. And I'm open to questions towards the end. So let's speak about dispute resolution as such. When we speak about dispute resolution, um, don't think necessarily of a very complex, big dispute. Think of something very basic. A company buys, let's say, mobile phones from another company, and they order 10,000, but that company only delivers 5,000. This is a very, very basic dispute, the non-delivery of goods. How are you going to resolve that dispute? Um, there are numerous possibilities. The most common one, and that's probably going to surprise you now, but it is still by far the most common one, is negotiation. Parties come together, company A, company B, and they discuss how can we resolve this. Maybe there is a reason why the company was not delivering 10,000. I mean, there's always a reason, but what I mean is they didn't necessarily want to defraud the other company. Maybe they were just, having problems with their supply chain. That's something we see a lot in COVID-19. So they come to discuss, and they just do it amongst themselves. And it can be people at the working level, it can be at the managerial level, it can be up to the CEO level, executive level. It doesn't matter. It's a very informal process. You then have mediation, and as you can see on the picture, there is the blue party and the yellow party, so to say, and you have the mediator in the middle who is helping the parties to find a solution. This is not a legalized process in the sense that what they discuss has very little to do with the law. Typically, the mediator doesn't even need to be a judge. Or sorry, I don't mean to say a judge, a legally trained person. So he or she doesn't act as a judge, so to say. The mediator will at most, but this is uncommon, make suggestions to the parties. What is more common, at least internationally, is called facilitative mediation. And the mediator is really just trying to help the blue team to communicate with the yellow team, so to say. This may sound strange to you, but think of the last time you had a fight with one of your friends. I don't know what it was. Maybe your friend borrowed something and didn't give it back on time, or your friend borrowed something and when she gave it back, it was broken. It can be anything, a broken promise. What I want you to do now is think back of that time. Initially, I believe you didn't really want to talk that much to your friend because you were upset. Or maybe you were so upset that you couldn't properly speak to a friend because it was more yelling. It depends on who you are, what type of person you are. But in this situation, when the third party comes in, and that's the mediator in this case, it is very helpful. We have conciliation, which in many ways is very similar to mediation. The main difference is that here the red guy, so to say, the guy in the middle, and guy is male or female in this case, is the one who would typically propose a solution. That's less common in mediation, but the borders are not entirely clear. You have expert determination, which is typically used for technical disputes. So when I mentioned before that only 5,000 phones were delivered, let's change the example. Let's say 10,000 phones were delivered, but 5,000 are not working. Now the question is there a technical defect which existed from the beginning, or did something go wrong during transportation, or has it occurred afterwards? This is not something which you need a legally trained person for to determine. It's rather a technician. So in this process, the expert, as the name says, technical expert, it can also be an expert on accounting or generally on damages, determines what went wrong, and you don't need to fight about everything. And it's more a dispute on the facts than on the law, so to say. You have adjudication, which is predominantly used in construction disputes. I'll not say more because it doesn't exist in Indonesia, except for contractual adjudication. You have arbitration. I think you've all heard about this. It's by far the most common form of dispute resolution that is used internationally. And you have litigation. Litigation is nothing but the court. So this, in brief, is the dispute resolution spectrum. And when we speak about ADR, in principle, what we mean is anything besides litigation. Some people make a further differentiation. They say ADR and arbitration, but it doesn't really matter how you use the term because there is no one way to use it. The way I will use it today is arbitration is included in ADR. You may note that on the far left and on the far right, there are two little black bars, which are still without a picture. And this is because there are two more ways to resolve disputes. And you may notice that the very left, it's the most peaceful way, so to say. On the far left, it's negotiation. You do everything on your own. On the far right, you need a judge who says, this is what's going to happen. But there are two more fields. The first one is flight. You can always choose not to do anything. You can run away like the yellow guy here, but you could also simply say, okay, they delivered 10,000 phones, except for two, all phones are working. I'm not going to make a big deal out of this. It's not worth the money. That's the one thing. The other thing is you can fight. This is something which I really do not recommend, but unfortunately, we see it quite often, maybe less so in Indonesia, but we do see it a lot in other countries, especially on Thursday, Friday, and Saturday nights when people get drunk. But you also see it sometimes, I mean, this is very seldom, but you sometimes see it with companies where they actually send in guys who will do something that's illegal. They sabotage you, or maybe they actually do send someone to beat you up. This is highly uncommon, fortunately, at least in those parts where we live, including Indonesia, but it may happen. So I want you to know about it. When we look at the international dispute resolution spectrum, and I'm here including everything, the types we see most often are negotiation, because it happens almost all the time, expert determination, and arbitration. And sorry, I just realized there should be one circle on mediation as well. Apologies for that. So today, I will mainly focus on arbitration and mediation. And this brings me to legal English. But before going there, you may ask yourself, what is the language which is used in IDR? And for IDR here, I use International Dispute Resolution. You see thank you on the screen in a lot of different languages here. And this raises the question, when you do disputes internationally, what languages do we use? And the best answer to this is the answer which lawyers love giving. It depends. So we are obviously always cautious. We never want to say exactly what happens. And it's the same for this question. It depends. But I will be more precise than that. Don't worry. What does it depend on? It depends where the buyer is from. It depends where the seller is from. And you can replace buyer and seller here with provider of service and recipient of service. That's one and the same thing. And it will depend on the easiest language between them. Now, what do I mean by easiest language? It sounds a bit vague or undetermined, but hang in there with me. Let's look at Indonesia and its trade partners. What countries does Indonesia import goods from? when you look at the next four lines, I put you on the screen the countries with which Indonesia had, or from which Indonesia received most goods in the year 2018. These countries account for about 70%. And when you look at the countries, sorry, I forgot one line, you may ask yourself, what language are the contracts going to be in? You have an Indonesian company on the one hand, and you have, say, a Vietnamese company on the other hand. What language is the contract going to be in? I think it's highly unlikely that the Indonesian company is going to speak Vietnamese. It's also highly unlikely that the Vietnamese company is going to speak Bahasa Indonesia. So in this case, it's very likely to be the easiest language between them, which is typically English. And I just picked Indonesia randomly. You can pretty much pick any country here, maybe with the sole exception being Malaysia. Maybe in a contract between a Malaysian party on the one hand and an Indonesian party on the other hand, the language that is used is Bahasa, both Bahasa Indonesia and Bahasa Malayo. But even then, I've myself seen contracts being drafted in English. One way or another, there may be exceptions. You may be a subsidiary of, say, a Chinese company in Indonesia, and because of that, you speak Mandarin. Maybe in that case, contracts will be in Mandarin. And the same, of course, applies for Japan, India, Korea, etc. But my point here is that on average, the easiest language when we look at Indonesia is going to be English. This is because, with the exception of Malaysia and maybe Brunei and to some extent Singapore, the Bahasa Indonesia is not so similar to any other language. So the easiest language to use, the language with which both sides speak, is going to be English. Now, when the contract is in English, it almost always means that the dispute resolution process is in English. And I'm telling you this because when the dispute resolution process is in English, then you need English when there is a dispute, and then ultimately you will need legal English. Because if you cannot make a legal argument, how can you possibly be a party representative in a international dispute where English is used? And the same, of course, goes when you are the neutral in the process, when you are the mediator, when you are the expert determiner, when you are on the arbitral tribunal. How can you resolve the dispute if you don't speak English when English is used? So my point here is that for Indonesia, on average, international contracts will be in English. Now, this is not the same for all countries. Let me give you an example that's far away from Indonesia. As you may know, almost all of South and Central America is speaking Spanish and Portuguese. There is one country which is Portuguese, Brazil. The rest, with the exception of Belize, is speaking Spanish. Now, if there is a company from Spain that does business with a company from Argentina, they would obviously not switch to English, because why would they change their mother tongue? However, let me tell you that even in those cases, when it's really they speak the same language, and from what I understand, Spanish from Spain and Spanish from Argentina are even much closer than Malaysian and Indonesian, and those languages are already very close. But even in this case, it may sometimes happen that a contract is drafted in English, and that's because there is someone who is higher up, maybe at the European headquarters or at the American headquarters or at the global headquarters, who wants to see the contract. Now, if that person does not speak Spanish, then the contract is going to be in English, whether you like it or not. So I'm telling you this to point out that even when it's very easy to communicate between two countries and ultimately then two companies, there is no guarantee that the contract will not be in English. On the contrary, sometimes it will still be in English, despite that. Now, let's move directly into dispute resolution. And I chose three examples from three of the most famous arbitral institutions in the world. I have nothing from mediation institutions because institutional mediation in terms of the numbers is minimal. We are speaking about a few dozen cases only, while for institutional arbitration, we are speaking about several thousand cases. So I simply ignored mediation, but I can tell you that in principle, it's the same. Let's start with the ICC. This is by far the best known international arbitration institution, although not the busiest, but it's by far the best known. And when it comes to their 2019 statistics, this is from where I took this, it says that basically almost 80% of arbitral awards were drafted in English. And when you look at the other languages, you can see that those are typically, or the majority of them are languages which are from countries in which the language is not only spoken in that one country, but in several other countries. For instance, French is not only spoken in France and Belgium, it's also, and Luxembourg to a very small extent, and Switzerland. It's also spoken, as you may know, in vast parts of Africa. Now, I don't know where exactly these awards are from, but I strongly assume that it's from one of those countries. Spanish, I mentioned that. Portuguese, it's the same with Portugal and Brazil. German, my mother tongue, is spoken in Germany, Austria, and Switzerland. So I strongly assume that the awards are from those countries. But you can see that 80% or 79 are in English. When we apply the Pareto principle, it would say that 80% is what accounts for what's the majority, and that's the case here as well. The 20, arguably, what the Pareto principle says is when you manage the most important 20%, it accounts for 80%. And you can see from here, there were 12 languages. If you only speak one language, that's much, much less than 20%, but it actually already accounts for more than, it accounts for almost 80%. The SIAC in Singapore says that it can administer arbitrations in other languages, but what I want you to pay attention to here is the last phrase. Where necessary, parties may be asked to provide translations of documents. Now, they put this on the website because, and I just took a screenshot from there, because, as I argue, while they have case counsel who speak those languages, they don't have all documents readily available in those languages. It's very hard to come up with 20 plus documents you need to administer an arbitration. And the third example I want to show you is the LCIA, the London Court of International Arbitration. Here, it only has its rules available in one different language. So this shows even more that English is the language which is used. This is a hard fact, and if you want to succeed in resolving disputes internationally, you need to master English. It's a hard fact you cannot work around. Now, I said you need to master English, but what skills do you need? You may be asking that yourself. I'm now predominantly thinking of what you would be doing after graduation, because you probably have 1 year, 2 years, maybe more left, but eventually you will graduate. And the typical job you will have where you do international dispute resolution is that of being a junior associate in a law firm. So what skills do you need to have there? The first one is reading slash researching. Very often when you do IDR, you have to deal with foreign laws. And often these laws exist in English, which may be the original language or a translation thereof. So you need to be able to read and to do research. It's not just the laws and statutory law. I'm saying this from my civil law background, but keep in mind that in many countries, the common law countries, there is much less statutory law, and court decisions matter a lot more. You have the principle of stare decisis, which means that lower courts must follow the decisions of higher courts. So researching is not only about statutory law, it's also about court decisions. It's also about articles in arbitration or generally international dispute resolution. People publish a lot. I'm currently working on 2 books, 2 book chapters, and I think 1 or 2 articles. Now, I'm a bit extreme because I very much like doing that. Not everybody is as stupid as I am, working so much in the free time, not getting paid. But there is a lot out there which you will need to take into account. So this is where you will need English most, I would say. So reading and researching is the #1 English skill, legal English skill you need to master. The second skill is writing. When you read something, it can also be the other side's brief, the brief they submit in arbitration. You need to read it, you need to analyze it, you need to research all the legal authorities, all the factual exhibits, etc. they have. But eventually you need to respond to that. If you only know how to read and get your facts straight, but you do all that in Bahasa, then that's not really helpful, because eventually you need to respond. Likewise, if let's go back to my example with mobile phones, and let's say that your client is the one who already paid for the 10,000 mobile phones, but your client only got 5,000 phones. You can research all the much you want. If you don't know how to write a legal brief, it doesn't really help you much, because you need to write something in order to start arbitration. So writing is another key skill that you as a junior lawyer need to master. And the good news is that that's pretty much it. It's only those 2 skills you really need to have. There is one more, which is speaking, but I can tell you that it's much, much less important in arbitration for junior lawyers. This is because when you are a junior lawyer, you will never be a firm, and then you will continue pleading. It's not going to happen. It's unless the dispute is really small, your boss does not speak English very well, you will not be pleading yourself initially. It takes a lot of time and practice, which is predominantly by watching others before you will be pleading your own case in an international arbitration. Now, there may always be exceptions. I, in the first case I got as an arbitrator, there was someone, an attorney from Denmark, who had participated in a moot court competition 3 years earlier in the Bismuth. And he then, in fact, was allowed to plead. But when we look at the speaking time he had and at the speaking time his boss had, he had about 5 minutes and his boss had about 2 hours. So you see that there is a huge difference. This is why I say that at least initially, speaking is much, much less important for you when you join a law firm. Now, all of this sounds great. You know what is required. You know you need to be able to read and research, and you know you need to be able to write. But how can you acquire those skills? How can you improve your English overall? I have a few recommendations, but keep in mind that those recommendations are really just some ways on how you can improve your English. They are not the only ways. The most important advice here is you must expose yourself to English, meaning you must use every single chance to absorb English, to be exposed to English. Don't go to the movies anymore when the movie is dubbed. You know, a lot of people think that they can only improve their English when they read legal texts. I'm speaking of lawyers here. That's nonsense. You know, of course, eventually you will have to improve your legal English, which means you need to become acquainted with legal terms. But if you only know the legal terms and you don't know the other terms, then that's not really going to help you. And we all watch movies from time to time, especially when we cannot leave the house in these times. So next time you watch a movie and you have the possibility to watch the movie in English, then watch it in English. Don't watch it in Bahasa. If that's very hard, then try turning on subtitles and eventually gradually improve so that at some point you don't need the subtitles anymore. This will greatly, greatly increase your understanding of English and your overall vocabulary, etc. You can listen to the radio or to podcasts in English, especially on the internet. And here again, you can choose something which is of great interest to you, or you can choose something very specifically about the law. It really depends on you. I'm listening, for instance, just to give an example, to a podcast called Freakonomics Radio. It's based on the book called Freakonomics, where the authors simply showed some phenomena in economics which are often perceived the wrong way. And this podcast has almost nothing to do with the law. The last episode I listened to spoke about the economic side of preserving the Amazon rainforest. So you see that there is nothing about the law. I like it, and it helps me improve my English because from time to time, at least at my level, there is still a term I wasn't familiar with. And, you know, to me, it's not really like I'm sitting down and, okay, now I have to study, and I don't really want to. To me, I enjoy this podcast, and I can simply enjoy it, and I improve my English at the same time. You can watch the news in English. I think these days, everyone can watch the news online. What you can do for a start is that you force yourself to watch one simple clip every day. That's like 3 minutes, you know. Don't tell me you don't have time for 3 minutes a day. And generally, you know, if you are really honest to yourself, then don't say you don't have time to listen to a podcast in English. That's you may think so, but when you're really honest to yourself, you will have enough time. You can read. Again, here you can start by reading a newspaper article. And the reason I say newspaper, because this is something which is short. It's not like it's a book and it takes you several hours. If you read one newspaper article a day, it's again going to take you 5 to 10 minutes. It must be a very long article if it takes you 10 minutes. What you can do is you read about these news in Bahasa first, so you understand generally what it is about, and then you read about it in English. It's going to make it easier initially. Eventually, you should get rid of reading it in Bahasa. You should just focus on the English. It doesn't need to be the news. It can be anything. I'm currently not doing it, but for a long time, I used to read The Economist every week. And for the avoidance of doubt, I'm not making any advertisement here, neither for Free Economics Radio nor for The Economist. I'm just telling you about what I did. The Economist is great because it's a very, very high level of English. You enrich your vocabulary, and this is why it's great. You can write. Writing, you can submit short articles to journals. You know, you can start with student journals and eventually build your way up. And there are numerous other ways. I'm just pointing out these because none of this has anything to do with ADR as such, but all of this can help you improve your English. What I want to point out here is also that what you need to do in order to improve your English is to learn from others. It's one thing if you learn on your own and study on your own. It's another thing if you see an article that's written in English by a native speaker and you analyze it, not on the law, but only on the structure. If you look at the structure, then you will see very often that the way it's drafted is in a very specific way, and that the author didn't just put heading, 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 and then conclusion, but actually thought very well about how to draft it. You may not see this right away at the first article because you know, articles are different and not every author puts so much thought into it. But the more you practice and the more articles you review, the easier it will be for you to see that. If you already work in a law firm and you're involved in an international dispute, you can analyze the briefs written by the other side. You can analyze the emails written by the other side. And that's one thing I want to keep in mind at all times when I say learn from others and possibly imitate them. You should always, with a very open mind, review and analyze what the other side says or someone else says, including what I say here today. Be open to it, but don't necessarily follow it. You should decide what is best for you and why you should follow this and not follow that. This should always be your decision. And no matter what people tell you, you should always be the one to find out what works best for you. You know, I spoke about watching movies here. Maybe you don't like watching movies. You should not force yourself to watch movies now just because I suggest it. This is just one way to do it, and there are numerous others. Maybe you think the news are very boring. Well, then watch a TV show instead, you know. My point here is that there are numerous possibilities on how you can improve your English, and you should find what works for you. Keep in mind, however, that eventually when we speak about legal English, you have to expose yourself to something with legalese, else it's not going to work. If you want to become a football player, you can play all sorts of sports initially when you are very young. But if you never practice how to play football, it's not really going to help you. You will never be a good football player. So the same applies here. Um, when I say watch movies in English, if you find that this is something you enjoy, then maybe try to find movies where part of it plays in court. Don't think that this is how it works in real life, because a lot of it is nonsense. But look for something like that. Watch a TV show. I mean, there are numerous shows with judges. Again, it's not always exactly as it is in real life, but at least you get exposed to the legalese. And the same, of course, for the listening and the writing.
Harold, I'm sorry. I'm sorry. I think we
You're on
have
time.
5 minutes left.
Yes.
Yep.
Okay, 5 minutes left. Okay,
Yes.
fantastic. Fantastic. Because I'm almost done. Thank you.
Sure,
a few recurring questions I often hear when I tell people that this is how they should improve their English. Do I have to go abroad? The short answer is no, you don't. I did go abroad a lot, and most of my English, I learned it while I stayed abroad. But I spent about 2 months in the US, and that's it for countries where English is the native language. So I'm the living example. I would say that you don't need to go abroad in order to improve your English. The way I improved my English was exactly as I have described. I simply exposed myself, and that's it. Do I need to take a course? No, you don't. Um, I'm generally against spending money when it's not necessary, especially when you are a student, because you shouldn't do that. I think everything I pointed out here has nothing to do with courses. It's all stuff you can do for free. It's all stuff you can do at home, and it's all stuff for which you do not need to pay. So yes, of course you can take a course. Yes, of course you can go abroad, but it's not necessary. Do I need to take an LLM degree? Same answer. You don't have to. In fact, I have noticed that quite a few people, and I'm not speaking about Indonesian students in particular, I'm generally speaking about foreigners who do an LLM degree abroad. When they go abroad, very often they feel sort of homesick, and they try to make friends with other people from their country. And what happens is that they end up speaking their own language while they are abroad, which is really stupid when you think about it. All the money you waste in the traveling and the living abroad, in the tuition fees. So I'm not saying you should not do an LLM. If you have the chance to do an LLM, then by all means do one, but you don't have to. It's really not necessary in order to um, learn about English or legal English in this case. You may ask yourself, what about my accent? Can I act in international dispute resolution if I have an accent? Well, I have an accent. It hasn't really stopped me, or it hasn't really hindered me in any way. Um, I'm definitely not as good as a native English speaker. And if I ever come across against someone who went to Oxford University and, has impeccable rhetorics in English, yes, I'm definitely not going to sound as smart when I speak. That's a hard fact. And likely for you, when you are non-native speakers, that's going to be the same. But it doesn't mean that it doesn't allow you to practice. Not at all. A lot of the best known people out there are not native English speakers. Yes, there are some who are native English speakers, but many of them are not. Think of Emmanuel Gaillard, who is, in my view, the most important pioneer of arbitration we have had in the last decades. He is not a native speaker, and he has an accent when he speaks. He still represented some of the in some of the most important cases in the world. It it hasn't changed anything about it. What if I make a mistake? Well, everyone makes a mistake. You know, I'm currently involved in arbitration proceedings where there's actually quite a lot at stake, and the chairperson is from India. Arguably, that chairperson should, with English being one of his native languages, arguably that person should be fluent in English and never make any mistake. Makes mistakes all the time. We're not speaking about really big mistakes, but mistakes happen. It's not the end of the world. You're not going to lose a case because you say he go instead of he goes. It's just a small example. Now, finally, and that's my last slide, Agaton.
Yes, please.
Common mistakes I see in IDR. And this is probably a bit advanced for you because you haven't participated in IDR proceedings yet. But once you will, keep that in mind, and it's going to help you, I hope.
Mhm.
Idioms are used the wrong way. Now, idioms are very often used in sports. We say to hit a home run. I don't know how many of you know what this means. It's an
Sorry,
idiom.
Gerald.
Yes.
Gerald, I'm sorry because we have quite a lot of questions.
Okay.
Can we summarize this part? Yes.
Yes. One issue is culture. I'll just point this out. I wrote to someone for one of the books that I'm writing on. This is a hard deadline. If you commit, you need to be sure that you can commit to this date. The answer is, I'm very honored to accept. I will do my best. This is a cultural thing. In some cultures, this means, yes, I will submit by then. In my culture, and I think generally in English, when you say you must commit, you cannot say, I will do my best. Because your best doesn't matter. You just have to do it. And finally, the wrong address. We see this in moot court competitions sometimes. Those who are inexperienced will address an arbitral tribunal as Your Excellency, instead of saying, I don't know, Miss Chairman or Mr. Arbitrator, or something like this. Okay, with that, terima kasih banyak. Thank you very much for your attention.
Thank you very much, Harold. It's a very informative and it's very great information. Thank you very much. So currently we have received numbers of questions, but due to the time limitation, I think I just gonna choose two questions with, I believe it also covers the whole idea of these topics.
Okay.
The first question is this. So some of us, because most of the participants are students, as we know, right?
Yes.
And students are learning in the process. And when they just figure it out that they want to involve in an international dispute resolution as their career path, but sometimes they think that it's kind of too late for them to start learning English and learning all the necessary skills. And when they graduate, they come to a law firm or other institution. Sometimes in work, the seniors, the partners even, are not really expecting them to learn, but what they expect is for them to work as best as they can, because they already work and they're not college anymore. Although we know learning is forever, right? So if some students face this kind of difficulties when they first graduate, what do you think they should do in order to keep improving while still committing in their work?
They should sleep less and work harder. No, I'm very strict on this. I do not accept the I don't have time. I raised two kids and I graduated from one university while doing that. It was only a postgraduate diploma, but still, I published a book. I published about 25 articles I have given speeches and lectures all the time. All of this is on top of my regular commitments. And I just worked harder and smarter. You know, I have no, I'm sorry I'm saying this so directly, but I have zero understanding for people who say I don't have time. This is not a sprint. This is a marathon. And no one can tell me that he or she does not have 15 minutes a day to study English. No one can tell me that. I don't accept it. And of course, if you only, so to say, study English for 15 minutes a day, you will not improve dramatically in a month. But what about half a year? What about a year? What about 2 years? What about 3 years? You know, this is a marathon once again. So just use your time wisely and get your priorities straight. Next time you sit on the
Great.
bus, don't play a silly game on your mobile phone, but instead watch the news, read the news. No, sorry, I'm very direct, but this is
Yes,
my
yes,
honest opinion.
that's good though. Yeah, right. But that's true though,
Yes.
and inspiring as well. All right. So another questions, and regarding to the ADR process, there's a questions regarding translators.
Mm-hmm.
So regarding the role of translators, how big is their role in a proceeding
Mm-hmm.
or in ADR process,
Mm-hmm.
and also are they also bound by the confidentiality rules and others procedural rules? Harry?
Everyone who is part of the arbitral process is bound by the same rules of privacy or confidentiality. And usually translators have to sign, or I should say interpreters have to sign confidentiality agreements. The difference to lawyers, of course, is that for lawyers, there are often professional rules which also apply, like the bar rules. An interpreter doesn't have them. Now, we use them twofold. The first one is to translate documents, but you don't need any sworn translator to do that. I recently translated a decision myself from German into English. It was a decision from the Swiss Supreme Court. So I took the German version and translated it into English. So that's the first part, the translation of documents, which can also be the translation of a witness statement, because some witnesses, as we know, do not speak English. And for them, it's possible to draft their witness statement in their own language, and then it's being translated. The other part is the oral hearing. And then I have never seen it that a counsel, you know, the lawyer, relied on an interpreter to make the pleadings. And I don't know if this has ever existed, but it would be very strange because you cannot
Yeah,
make good advocacy if your pleadings are translated.
true.
But if the witness comes to the oral hearing, then of course the witness will say something and the interpreter has to interpret it. And this is very common. I don't want to say in every single arbitration, but I would say on my experience, in the 70 plus that I was personally involved in, maybe in about 30 or so, we had a translator.
Right. And that's also why we as lawyers we need to study English, because it will be very hard, right, to argue with the translators.
Yes, you usually don't argue because the translator is usually independent, but it may happen. In the same, I mentioned the first time I said as an arbitrator, in the same arbitration, an interpreter was used who was not used to translating in court or in arbitration. And she would start off by saying, he said that. Now, this is wrong because an interpreter should never say he said that. The interpreter should say, I say that, because the interpreter should not put everything in indirect speech, but only translate one-to-one. It's English is important, however, to emphasize your point. because sometimes an interpreter will use the wrong term. And
Mm-hmm.
if you can speak the language properly, then you can caught that mistake. It's hardly ever intentional. I've never seen this, but it may happen by mistake, and then it's good if you can correct it.
Mm-hmm. And I think one last question, Harold, because we are very grateful to have you here, and
So am I.
the students are eager to learn from your success career path. So, as a non-native English speaker, can you tell us your a bit of your journey and until you can become an international arbiter? Of course, it's not an easy way for you, right?
um, there are numerous ways to do it and numerous ways to achieve it. What I always ask you to keep in mind is don't be naive. Naive in the sense that when you are below 40 and you act as an arbitrator, it's still quite uncommon. Usually, acting as an arbitrator starts much later. Now, definitely, it's not impossible. Many of my friends have done it way below 40, and so did I. But it's not easy. My success factor, so to say, I don't want to call it a secret because it's not nothing special. But my success factor was finding a niche. You know, finding something
Mm-hmm.
that only I can do and that no one else can do. Um, and there are at broad two factors. The first one is I have an MBA degree, and
Mm-hmm.
you heard me say I read The Economist, I listen to Freakonomics Radio. Thus, I have a lot more interest for numbers than the average lawyer does.
True.
This has never brought me any case as an arbitrator, but as counsel, yes. Um,
Uh-huh.
and my other success factor is foreign languages and foreign culture. This first
Mm-hmm.
arbitration, I got it because one party was from Korea, the other one was from Denmark. I am
Mm-hmm.
fluent in Korean and I speak some Danish. And I've lived for some time in both countries. So this has put me in a very unique position where I was very well suited. So this is my success factor, but that's just one way to do it. Now, please do not think, oh my God, I have not lived abroad yet. I can never achieve this. That's nonsense. It's just the way I
True.
did it.
True.
And many other people, find something else. A friend of mine has managed to be extremely close to an arbitral institution, and
Mm-hmm.
he stays in his country all the time. He doesn't go abroad, but he has acted in arbitrations as an arbitrator a lot more often than I have. So you
Mm-hmm.
can see that there is there is not just one way.
All right. Okay. So I guess just to summarize a little bit from your presentation as well that although we are non-native English speaker, uh, we can use it as an advantage, like what you did, and in your success career path. And what we need to do is just to learn more, to learn harder, and because this journey is not a sprint, but rather it's a marathon. So as long as we fight and we strive for our best, and especially to learn English because it is very important in the international dispute resolutions. So, born as a non-native English speakers is not an issue, and it's not something that we should regret.
Yes,
Okay. Yeah.
I very much agree to that summary, especially that if I may emphasize just one point,
Mhm.
um,
Sure. Sure.
not being a native speaker can in many ways actually be a huge advantage. Um, think about it from this perspective. Um, all of you, well, I assume all of you are from Indonesia. So you are from, never forget this. I know a lot of people sort of look down on Indonesia, and a lot of Indonesians complain about Indonesia. and they keep pointing out what's going wrong about Indonesia. Now, I'm a foreigner, I'm not to judge, but something I want to judge on is keep in mind that already at this point, Indonesia is one of the most important countries in the world economically, and its importance will only grow in the future. Now, maybe now Indonesia is behind in international arbitration compared to other countries. But 10, 15, 20 years down the road, when all of you will still be in the middle of your career, um, Indonesia will be much more important. And then speaking Bahasa, especially if you work abroad, is going to be a huge, huge asset. And this is something that is often a huge advantage that we have over native English speakers, because for them, it's much, much harder to expose themselves to another language, to a foreign language. Um, for us to expose ourselves to English is much, much easier. And therefore, I fully agree with what you say, Agaton. It's actually an advantage.
Yeah, great. All right, Harold. So although it's very interesting to talk and to discuss to you, but due to the time limitation, I think
Sure.
this is the end of our discussion. Thank you very much, Harold, for the time, for the discussion, for the materials, and we hope that we can continue our discussion with all the participants here. Sometimes after, of course, after this COVID-19 pandemic, and we hope we can gather around offline so we can catch up and talk much more regarding this dispute resolution. So once again, thank you, Harold. So
Thank
stay
you.
safe, take care. Yes.
I again echo what you say. It would be great to catch up. To all the
Mhm.
participants, also from my side, thank you very much. To the organizers, thank you for inviting me. And I wish you happy learning in the afternoon when you will negotiate. Thank you very much.
All right. So thank you very much to all participants. Thank you very much, ALSA Indonesia, for having us. So good afternoon. Thank you. Goodbye. And ALSA always be one. Thank you.
Bye bye.
Bye.